Greetings, ELPIS scholars. It's an honor to be before you, and I'm honored today to be talking to you about South Africa v. Israel, which is pending before the International Court of Justice, and of course involves the human rights catastrophe surrounding the Israeli invasion of Gaza after the October 7th, 2023 terrorist attacks by Hamas on Israeli citizens. So let's get right down to it. Let's start off, right? And hold on, let me get my screen sharing. Hold on, let me make sure I got my screen sharing going. And I think I have it here. And so South Africa v. Israel. So what are the key facts? Let's just get to some. I know some background is always necessary. So what are some of the key facts that we can talk about here? The state of Israel, as you all know, right, the only Jewish state in the country, in the world, was created in biblical Palestine in 1948 based on Zionism, an intellectual movement founded in Central Europe by Theodor Herzl that sought a Jewish state as a means of protecting Jews from millennia of pogroms and other forms of anti-Semitism, right? Jewish migration from Europe to biblical Palestine grew dramatically after World War II, when between 4 to 6 million Jews were killed by the Nazis and their collaborators in Western and Central Europe. After the creation of Israel, Jewish migration from the Middle East and North Africa grew dramatically after Arab states such as Egypt stripped Jews of their citizenship and forcibly expatriated from countries where they had lived for millennia, right? Israel also consists of large numbers of Ethiopian Jews who arrived in Israel starting in the 1980s, Central and Eastern European Jews who arrived in Israel after the collapse of the Soviet bloc, and significant numbers of American, Canadian, South African, and Western European Jews who have dual nationality with other rich countries and typically are at the top of Israel's socioeconomic pyramid. Israeli Zionism claimed biblical Palestine was a quote-unquote land without a people, but as we all know, there have been Palestinians who have been inhabiting that land continuously for millennia. The Palestinian people, right, had been living continuously in biblical Palestine for millennia under the Umayyad Caliphate, the Abbasid Caliphate, of course, the Ottoman Turks, and after the British and French defeated the Turks in World War I, the British mandate that followed the Sykes-Picot Agreement between Britain and France. The Palestinians understandably rejected the creation of Israel because it would have made them, in a Jewish state, second-class citizens. After Israel was granted statehood by a majority vote at the United Nations in 1948, Arab armies from Egypt, Syria, Iraq, and Jordan invaded Israel, and Israel successfully repelled this invasion, and in the process, forcibly expatriated large numbers of Palestinians from what is now Israel into Lebanon, Jordan, and the Gaza Strip. It also took control of what is now called West Jerusalem and claimed it as its capital city. The 1967 war, and it's is what we're going to move to next, right? And in the 1967 war, Israel commenced this war in 1967 after there was very, very hostile language used by Arab states against Israel. Paradigmatic example was, over-the-top propaganda by Nasser's Egypt about defeating Israel. And Israel commenced what it called a preemptive war in 1967 that lasted only 6 days, but it was a stunning victory for the Israelis, who defeated Egypt, Syria, and then Jordan. The result of the war in 1967 was that Israel took control of the Sinai Peninsula from Egypt, and that was returned to Egypt after the Camp David peace accords between Israel and Egypt in 1982, and both East Jerusalem and West Jerusalem from Jordan. Both East Jerusalem and the West Bank were inhabited by Palestinians, and Israel began building Jewish settlements to change the demographic makeup there, right? These settlements were subsidized by Western countries effectively, especially the United States and Germany. And the settlement building increased dramatically in scope after the arrival of former Soviet Jews into Israel after the collapse of the Soviet Union in 1991. Another really important historical moment was the Gulf War, right? After Saddam Hussein invaded Kuwait and purported to be an agent of Arab liberation, Yasser Arafat, right, the head of the Palestinian Liberation Organization, sided with Hussein against Saudi Arabia, the Gulf states, and the United States. In retaliation, oil-rich Arab states such as Saudi Arabia and Kuwait expelled their Palestinian populations and, more importantly, ceased providing the Palestinians with needed funding. This left the PLO without resources and paved the way to the American-backed Madrid Peace Conference that, after the Gulf War, sought to build upon the Camp David peace agreement between Israel and Egypt, such that peace could be achieved between Israel and all of its Arab neighbors. The key point here, though, is that all Arab states paid lip service, I would say, to the importance of creating a Palestinian state, but all were either hostile to the Palestinians, the Exhibit A being the Saudi Arabians, or too weak to confront Israel, and Exhibit A in that situation was Jordan, right? So this then led to the Oslo process. The end result was that the PLO was forced to effectively surrender, whereby it would accept Israel and recognize Israel, and in return, be allowed to return to the Israeli-occupied West Bank and Gaza Strip in the hopes that a peace agreement could be negotiated in the future that would allow for a Palestinian state. The Norwegians who brokered this Oslo process, their supposition was the level of hostility and mistrust between the parties was so great that if you could focus on the small things first, like somewhat living together side by side, eventually over time, the bigger issues could be resolved, such as, for example, the status of Jerusalem and the creation of, for example, a viable Palestinian state to live peaceably alongside Israel. But this process collapsed after Israel and the Palestinians were unable to come to an agreement at Camp David at the tail end of the Clinton administration. Both sides pointed fingers at each other, but the source of the problem was that Israel was fundamentally too strong to make compromises for peace, such as ending settlement construction, and the Palestinians were both too weak and divided to confront what, with Western support, had become a regional superpower, both due to exceptional Israeli human capital and huge amounts of bilateral military and financial assistance provided to Israel by the United States, Germany, and the international Jewish diaspora, right? Problematically, too, the Palestinians, lacking international support and frustrated by the pace of self-determination, and the continued growth of settlements, continued to grow weaker and effectuated inhuman acts of terrorism, right, that alienated moderate elements in Israeli civil society and, of course, broader elements of Western public opinion. Right? I think also another factor is the Palestinian acts of terrorism were seen in a particularly, of course, inhumane and violent as they were. They also must be seen in the context of 9/11 and the overall Western concern about terrorism, which furthered Western support for Israel. Now, Gaza. What about Gaza? Gaza, as we'll talk about later, is a kind of like a prison, an open air prison, is what Palestinians would say. And Israel, right, withdrew from its occupation of Gaza and dismantled all Jewish settlements from Gaza in 2005. That was done by Prime Minister Sharon. However, Israel, rather than allow Gaza to be self-determining, placed Gaza under a severe security lockdown and denied Gazans the ability to communicate with the outside world by placing it under a security lockdown. This is why Gaza has been called the world's largest open-air prison, and living standards in Gaza before October 2023 were amongst the lowest in the world and were significantly lower than living standards for Palestinians in the West Bank and dramatically lower for Palestinian citizens of Israel. Okay? So to put it, to give you an idea, Israelis increasingly have living standards akin to Western Europeans. In other words, the average Israeli Jew's living standards is somewhat similar to that of a Spaniard, a Portuguese, or a French person. In fact, by some measures, per capita income in Israel is equal to that of the United Kingdom. Below that of Israeli Jews, but still quite high by international standards, is per capita income for Palestinian Israeli citizens. And Palestinians Israeli citizens are about 20% of Israel's population. But much below that are Palestinians living in the occupied territories. Of those, the lowest living standards that are even below those of Bangladesh, would be the living standards of the Gazans pre-October 2023. Okay? And problematically for the Gazans is the prison-like conditions appear to have no end in sight at the time of the October 2023 terrorist attacks. Let's go back in time. There were very, very legitimate criticisms made by Israeli civil society against Benjamin Netanyahu's government on the eve of the terrorist attacks. And those criticisms involved, rule of law retrogression, authoritarianism of and the movement of the Israeli government against the Israeli Supreme Court, et cetera, et cetera. But very few criticisms leveled against Netanyahu focused on creating a Palestinian state. So the Palestinians, weak as they were frustrated by the fact there was no movement within Israeli civil society towards creating a Palestinian state. And problematically, there was no international pressure in that regard as well, especially since the most important member state in the international system, the United States, is very beholden to its pro-Israeli lobby in dealing with the Israeli-Palestinian dispute. So on October 7th, 2023, what happened? The terrorist group Hamas commenced a deadly and horrific terrorist attack that day that killed more than 1,200 Israelis. And beyond just killing, it involved horrific raping of Israeli women. And Hamas, beyond that, committed a terrible crime by kidnapping 251 Israelis, including babies, infants, and the elderly, and transported them back to the Gaza Strip to be held as hostages. And this was a tremendous, tremendous trauma on Israel, because I think for a long time, Israeli civil society had thought the Palestinians were probably too weak to effectuate a terrorist attack of this type. And this led Israel to commence a war in Gaza that involved, well, first of all, before the war, Israel immediately put the entire Gaza Strip, more than 2.5 million people, on lockdown, shut off all power, cut off all water, and shut down all communications. And then it commenced a war on Hamas that involved collectively punishing the entire Gaza population. As of August 7th, 2024, which is today, more than 39,000 Palestinians have been killed, and 2.3 million Gazans have been driven from their homes and forced to live in either tents or rubble with grossly insufficient amounts of food and drinking water, you just have to look at the pictures, and the pictures of Gaza look no different in the level of destruction than the pictures we saw after the terrible, the pictures of, I would say, of Aleppo that we saw after what the Assad regime, assisted by the Russian Federation, did in Aleppo to clamp down on pro-democracy protesters. Malnutrition and communicable disease are rampant, and the Israeli military endeavor is being subsidized to this very day by military support from the United States, Germany, and other Western countries. So now, of course, let's take another brief look at history. Israel, after it was created, was basically isolated from its region. In other words, none of the Arab states recognized it. Israel did have very good bilateral relations with Turkey and the Shah's regime in Iran until the Islamic Revolution of 1979. But Israel, outside of the Western states, was relatively isolated, and Israel did have very, very good relations with the apartheid regime in South Africa, one of the things that's worth remembering is Israel is one of the nuclear states in the world. It has an unofficial, it's not come out and declared itself to be a nuclear state, but it has a nuclear arsenal. That was largely provided to Israel. The initial nuclear program was provided by the French government in the 1950s, but the weapons grade elements of the nuclear arsenal Israel had was actually provided by apartheid South Africa, right? So Israel had a very good relationship with apartheid South Africa, though apartheid South Africa, as we all know, was committing a grave crime. An international jus cogens norm was being violated by its system of apartheid. And that's why, and here I have, of course, a picture here of Nelson Mandela with UN Secretary General Antonio Guterres. This is before Mandela, of course, passed away. Mandela had great affection, and the ANC, the African National Congress, which became the governing party of South Africa upon majority rule, always had very good relations and took a sympathetic view of the Palestinians in the Israeli-Palestinian dispute. And as a result, the Republic of South Africa to this very day, right, has officially relatively hostile relations with Israel because it sees and it remembers the fact that Israel was not an ally in seeking majority rule and in fact supported the pre-apartheid regime. So now let's look as to why South Africa might have sought intervention through the International Court of Justice. Let's look at the UN Charter here. And it says here that the Charter of the United Nations was signed on June 26, 1945 in San Francisco, right? And it says, the statute of the International Court of Justice is an integral part of the Charter. Chapter 3 provides there are established as the principal organs of the UN, a General Assembly, a Security Council, an Economic and Social Council, a Trusteeship Council, an International Court of Justice, and a Secretariat, right? So that's in Article 7. Article 36 provides, right, the Security Council should also take into consideration that all legal disputes should, as a general rule, be referred by the parties to the International Court of Justice in accordance with the provisions of the statute of the court. So the United Nations framework was to disallow, right, international disputes to be effectuated by war. And if states have disputes amongst each other, to go to the ICJ, right? And that's what Article 36 provides. And then here is, right, Article 92. It says that the ICJ shall be the principal judicial organ of the United Nations. It shall function in accordance with the annexed statute, which is based upon the statute of the Permanent Court of the International Court of Justice and forms an integral part of the present charter. In Article 93, it says that all UN members are parties of the International Court of Justice statute. A state which is not a member may become a party, right? So by way of example, you could have an informal situation where a state could join, right? 96, the General Assembly or the Security Council may request the International Court of Justice to give advisory opinions. That's one thing, right? An advisory opinion requested by the General Assembly, which consists of all 194 member states, or the Security Council, which consists of 15 members, 5 permanent members being, of course, the United States, the Russian Federation, China, and based on historical circumstances, the United Kingdom and France, right? Right? The court shall be composed, it says here in Article 2. This is the organization of the court, right? It says the court shall be composed of a body of independent judges elected regardless of their nationality from among persons of high moral character who possess the qualifications required in their respective countries for appointment to the highest judicial offices or are jurisconsults of recognized competence in international law. It says here in Article 3, It shall consist of 15 members, no two of whom may be nationals of the same state. Okay? In other words, if the United States has a judge on the ICJ, you can't have a second American. Or if there's a Portuguese national on the court, you can't have a second Portuguese person, right? In Article 8, it says the General Assembly and the Security Council shall proceed independently of one another to elect members of the courts. In other words, they're elected separately, bicamerally, right? The judges of the court. The competence of the court in Article 34, it says only states may be parties in cases before the court. So, for example, South Africa v. Israel. The court, subject to and in conformity with its rules, may request of public international organizations information relevant to cases before it, and shall receive such information presented by such organizations on their own initiative. Right? So as we're talking about here, as we just discussed, the ICJ is the principal judicial organ of the UN. It was established in June 1945, right? The court sits at the Peace Palace in The Hague, which is in Holland. Of the 6 principal organs of the United Nations, it is the only one not located in New York. The court's role is to settle in accordance with international law legal disputes submitted to it by states and to give advisory opinions on legal questions referred to it by the United Nations organs. And as I just said, it is composed of 15 judges who are elected for terms of office of 9 years by the UN General Assembly and the Security Council. Its official languages are English and French. Okay? As I just said, right? 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 So here are the current members of the court. There's President Nawaf Salam. He's Lebanese. We can say plausibly, if you know political culture, there could be a slight bias there in favor of the Palestinians in that framework, right? Vice President Julia Sebutinde is Ugandan. She's consistently been the only judge who's voted with Israel, as we'll discuss shortly, in these disputes. This might have to do with the fact that she's a evangelical Christian and a member of the Christian Church of Zion in Uganda. That may be something, right? There's Judge Peter Tomka, who's Slovakian. Judge Ronnie Abraham is French. Okay? Judge Abdul Gawi Ahmed Yusuf is Somali, right? And that plausibly, being Somali, he might be slightly more sympathetic to the Palestinians. Judge Su Hankin is Chinese, and the Chinese have tended to side with the Palestinians to some degree. Judge Baldir Bandari is Indian. Who knows if there's bias there? India does have very, very good relations today with Israel, not with the Palestinians. That's under the government of Narendra Modi. There's Judge Iwasa Yuji, who's Japanese. Judge Georg Nolte is Germany, and as we know, Germany is one of Israel's strongest allies. Judge Hilary Charlesworth is Australian, and Australia has always had excellent relations with Israel. Judge Leonardo Nemer Caldero Brandt is Brazilian. And Judge Manuel Gomez Robledo is Mexican. Mexico has always had also historically very good relations with Israel. Judge Sarah Cleveland is an American. She's a professor at Columbia University Law School, and we know the United States has very good relations with Israel. Judge Bogdan Lucian Aurescu is Romanian. Judge Dire Tladi is South African. And because there's a South African judge on the panel, it was allowed for an interim Israeli appointee, and the Israeli appointee is, of course, the extremely highly regarded Israeli scholar, public intellectual, and former Chief Justice of the Israeli Supreme Court, Aharon Barak. Many of you probably are most familiar with Aharon Barak's name because he was Attorney General at the time Menachem Begin negotiated Camp David with Sadat during the Carter administration. But Barak is an extremely capable figure and one of the great jurists of the world and public intellectuals. So the ICJ operations, let's just go over this again. It may entertain 2 types of cases, as I said earlier, legal disputes between states, submitted to it by them. And that's what happened here. And of course, advisory opinions, right? Right? And how about enforcement? By signing the charter, a member state of the United Nations undertakes to comply with the decision of the court in any case to which it is a party. Since furthermore, a case can only be submitted to the court and decided by it if the parties have in one way or another consented to its jurisdiction over the case, it is rare for a decision not to be implemented. A state which considers that the other side has failed to perform the obligations incumbent upon it under a judgment rendered by the court may bring the matter before the Security Council, which is empowered to recommend or decide upon measures to be taken to give effect to the judgment. Now, of course, that's the problem here, because it is very doubtful that the United States would do anything but veto a measure brought to enforce any ICJ opinion against Israel at the Security Council. Right? There are many pending cases, as you can see, that are currently going on, right? For example, there's a case involving genocide brought by Gambia against Myanmar. Myanmar, of course, is, I think, clearly committing acts of genocide against its Rohingya minority. There's still a case pending between the United States and the Islamic Republic of Iran going back to 1955, when Iran basically was alleged to have taken American, basically going back to 1955. There's other cases involving Hungary, Slovenia, right? There's the cases involving the Iranian seizure of Western assets stemming from the 1980s, right? And so there are various cases. Altogether, there's about 21 cases that are currently pending before the ICJ, okay? Including the case that's the subject matter today, which is South Africa v. Israel, right? What South Africa is alleging in the South Africa-Israel is that Israel is committing the crime of genocide against the Gazans. The crime of genocide is defined in Article 2 as, right, any of the following acts committed, and the key word here is with intent to destroy in whole or in part a national, ethnic, racial, or religious group as such. A, killing members of the group, right? Causing serious bodily or mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, imposing measures intended to prevent births within the group, and forcibly transferring children of the group to another group, okay? And this genocide convention really stemmed from the work of a European immigrant to the United States by the name of Raphael Lemkin, who came up with that definition of genocide, which was then adopted and became a jus cogens norm in international law. The Convention of 1948 has now been signed by 153 UN members, right? It was ratified by Israel in 1950, ratified in South Africa only in 1998. The reason South Africa delayed it was its concern was the argument was clearly made that apartheid violated the Genocide Convention. The United States, as you can see, only ratified in 1988, and the concern until then, right, and what prompted the United States to sign on to it was Ronald Reagan making a political mistake and saying that he was involved in liberating the concentration camps in Europe when he never served in World War II. And he made that claim in 1984, and that led the US to finally sign on to the Genocide Convention. The concern the United States had until then was that the Genocide Convention might have been violated if the United States had signed on by the American policy of racial segregation in the South. As you can see, Portugal only ratified in 1999, but other countries ratified much before that. Germany, for obvious reasons, in 1954, Spain in 1968, India in 1959, and Canada in 1952. Okay? So on December 29, 2023, South Africa filed in the International Court of Justice Registry an application instituting proceedings against Israel concerning alleged violations in the Gaza Strip of the Convention on the Prevention and Punishment of the Crime of Genocide. It contained a request for the indication of provisional measures whereby South Africa requested the court, as a matter of extreme urgency, pending the court's determination of this case on the merits, to issue provisional remedies to protect the Gaza population. In other words, it was saying, kind of like in an American court, when you seek a preliminary injunction before the case has been adjudicated on the merits and all evidence has been taken, it was saying, we know the case is pending, but South Africa said, we need an immediate order because the situation of the Gazans is so dire, right? Right? And these provisional measures is what it says. It asks for Israel to it asks for a court decision asking Israel to immediately suspend its military operations in and against Gaza, that Israel shall ensure that any military or irregular armed units which may be directed or supported or influenced by it, as well as any organizations and persons which may be subject to its control, direction, or influence, take no steps in furtherance of the military operations referred to in point 1 above. It says that the Republic of South Africa and the State of Israel shall each, in accordance with their obligations under the Convention on the Prevention and Punishment of the Crime of Genocide, in relation to the Palestinian people, take measures within their power to prevent genocide. It says that Israel, it's asking for a court decision to say that Israel, right, shall, in accordance with its obligations under the convention, right, stop from commission of any acts within the scope of Article 2, in particular, stop killing members of the group, in other words, stop killing Gazans, causing serious bodily or mental harm to the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. And it says that Israel shall, right, stop and take all measures, right, to stop, for example, the expulsion and forced displacement of people from their homes, the deprivation of access to adequate food and water, access to humanitarian assistance, including access to adequate fuel, shelter, clothes, hygiene, sanitation, medical supplies and assistance, and the destruction of Palestinian life in Gaza, right? It says it's asking for a court decision. It asked that in relation to Palestinians, ensure that its military, as well as any irregular armed units or individuals, right, to not commit any acts or engage in any direct and public incitement to commit genocide, conspiracy to commit genocide, attempt to commit genocide, or complicity in genocide. What that kind of refers to is there's been a lot on the from Israeli right-wing politicians, a lot of arguments. For example, people have said very vocally, Palestinians should all be expelled, etc., or killed. It also asks Israel to take effective measures to prevent destruction and ensure the preservation of evidence related to allegations, right? Now, the obvious rejoinder to this, and Judge Barak points this out, is the Israelis didn't commence this operation sua sponte, on their own initiative. It was a very traumatic response to the fact that 1,200 Israelis had been brutally murdered, more had been raped, and at least 250 had been kidnapped. The fact of the matter is, no Western mature democracy or no developing nation would take that lying down. The Israelis had to react. That's a fair statement. What this is basically arguing, though, is that the Israeli statement, though, was beyond proportionality and crossed the threshold and was basically and contravened the Genocide Convention. Right? And so the court issued a decision on January 26, 2024, basically saying Israel, has to take measures to, stop killing members of the group, causing serious bodily or mental harm to members of the group, deliberately inflicting on the group, conditions of life calculated to bring about its physical destruction in whole or in part, imposing measures intended to prevent births within a group, right? The decision also says that Israel shall ensure with immediate effect that its military does not commit any acts that we just mentioned, right? And that it shall take measures to prevent and punish the direct and public incitement to commit genocide in relation to members of the Palestinian group, that Israel shall take immediate and effective measures to enable the provision of urgently needed basic services and humanitarian assistance. As we all know, Israel claims humanitarian assistance is getting to the Palestinians. The Palestinians and the vast majority of international of the evidence indicates only a trickle is getting in view of the need, right? It also says that Israel must submit a report to the court on measures taken to give effect to this order within 1 month from the date of this order, right? The court expressed its grave concern, though, over the fate of the hostages abducted during the terrorist attack and held since then by Hamas and other armed groups, and called for their immediate and unconditional release. The court writes that it finds it deeply troubling that many of these hostages remain in captivity, and reiterates its call for immediate and unconditional release, right? We move forward now. Now, the previous court decision was basically a 15-2 decision, an overwhelming majority finding against Israel. The only two judges who sided with Israel, understandably, are Judge Barak, but also Judge Vice President and Judge Sebutinde from Uganda. Interestingly, the government of Uganda said they did not endorse her opinion at all, right? And Sebutinde most likely, I think, sided with Israel. It might have been her religious background that might have touched on that. I don't know. But it also could be just a matter of integrity on her part as well. Let's move forward. Now we're at Rafah. It's February 12th, 2024. By a letter dated February 12th, right, South Africa referred to the developing circumstances in Rafah. In other words, the Palestinian population of Gaza was pushed out towards Rafah, which is closer to the Egyptian border with Gaza, and it was looking like a humanitarian catastrophe. Basically, the Palestinians, they're all living in basically rubble or tents. There's no food, there's no running water, there's no means of sanitation, right? And the Israeli government had made noises about a sort of Carthaginian invasion of Rafah, which led South Africa to issue this request for the court's intervention. And this led to the court, right, issuing a decision on February 16th, right, saying that the most recent developments in the Gaza Strip and in Rafah would exponentially increase what is already a humanitarian nightmare with untold regional consequences, right? The perilous situation demands an immediate and effective implementation of the provisional measures of January 26th, which are available throughout the Gaza Strip, right? The court emphasizes that the state of Israel remains bound to fully comply with its obligations under the Genocide Convention and with the said order, including by ensuring the safety and security of the Palestinians in the Gaza Strip. On February 26th, right, Israel submitted, within the time limit for that purpose, a report on all measures taken to give effect, right, to the court's order on the indication of provisional measures on January 26th, okay? Going further, then, South Africa once again seeks court intervention to seeking further provisional measures as the situation in Gaza gets even worse. In other words, nothing's stopping here, right? And this leads to a decision on March 28th, right? And this is what it reads: in conformity with its obligations on the Genocide Convention and in view of the worsening conditions of life faced by Palestinians in Gaza, in particular the spread of famine and starvation, it says that Israel shall take all necessary and effective measures to ensure without delay, in full cooperation with the United Nations, the unhindered provision at scale by all concerned of urgently needed basic services and humanitarian assistance, including food, water, electricity, fuel, shelter, clothing, hygiene, and sanitation, as well as medical supplies and medical care to Palestinians throughout Gaza, including by increasing the capacity and number of land crossing points and maintaining them open for as long as necessary, and ensure with immediate effect that its military does not commit acts which constitute a violation of any of the rights of the Palestinians in Gaza as a protected group under the Genocide Convention. Okay? The court further considers that the catastrophic situation in Gaza confirms the need for immediate and effective implementation of the January 26th order, right? Which are applicable throughout the Gaza Strip, including Rafah, right? The court considers that Israel must submit a report to the court on all measures taken to give effect to this order within 1 month, just as they did on January 26th, okay? Once again, now, May 10th, South Africa seeks further court immediate measures, right? In other words, what's going on, the case has not been finally adjudicated on the merits, but South Africa is asking, what's happening is these things are happening. Terrible things are happening in Gaza, and Israel is not stopping. Most likely, I think, if we can be honest about it, it's because of the trauma inflicted on Israeli civil society and the Israeli population by the Hamas terrorist attacks. Recognizing, okay, that it is a jus cogens norm, though, that that a population under occupation, like the Palestinians, right? A population under occupation, right, cannot be retaliated against, okay? And so that came out from an ICJ decision in 2004, right? But Israel, I think we have to be quite honest with this. When Israel is hearing the ICJ issue these decisions, I think most Israelis and Israeli academics, Israeli civil society, they feel, right, at this moment that the international community is being unsympathetic to the trauma they suffered on October 7th. On the flip side, the Palestinians are feeling consistently, and the global South movement that is sympathetic to the Palestinians feels that international law, that the lack of movement of this case evidences that international law is basically not law in a sense, and is basically, right, the rule of the strong, especially those ruled by the powerful member states of the mature democracies, especially the United States, and it disregards the lives of people from the global South, such as the Palestinians. So on May 24th, the court issues yet another decision. The court considers that in conformity with its obligations under the Genocide Convention, Israel must immediately halt its military offensive and any other action in the Rafah Governorate which may inflict on the Palestinian group in Gaza conditions of life that bring about its physical destruction in whole or in part. Right? The court recalls that its order of January 26th, it ordered Israel to take effective measures to prevent the destruction and ensure the preservation of evidence related to allegations of acts within the scope of Article 2 and Article 3 of the Genocide Convention. In the present circumstances, the court is also of the view that in order to preserve evidence related to allegations of acts falling within the scope of Article 2 and Article 3, Israel must take effective measures to find the unimpeded access to the Gaza Strip of any commission of inquiry, fact-finding mission, or other investigative body. In other words, this is the response at the hearing on this matter. The Israeli argument was, there's no evidence of genocide. But the South Africa's argument was international monitors and fact finders are disallowed from entering. So they're saying, what they said is, how can you claim there's no evidence when you're, as a defense, when you're precluding evidence gathering? The court also considers that the catastrophic situation in Gaza confirms the need for the immediate and effective implementation of the January 26, 2024 and March 28th, 2024 measures, right? It also says that Israel must submit a report to the court on all measures taken to give effect to this order within 1 month, okay? And so that's what we saw here is South Africa commenced this matter based on what it perceived to be Israel's excessive response that violated its interpretation of the Genocide Convention uh, in 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 response to the October 7th, 2023 terrorist attacks. What it seems to indicate here, this decision, is the South Africans, at least at this stage, have won the argument, but not the dispute, in the sense that they've won the argument with Israel, in that the court, by an overwhelming majority, seems to be siding with South Africa's position, is siding, I should say, with South Africa's position that there's enough evidence there to find that Israel's actions against the Gazans contravene the Genocide Convention. The problem is, at the end of the day, the International Court of Justice seems to not be in a position to have its orders be effectively abided by Israel. And there's fundamentally several reasons for this. I think the most important reason for this is the Israelis are right now too traumatized and too emotional to hear what the ICJ is saying. And I think it perceives the ICJ is being wholly unfair to Israel and discounting the trauma Israel suffered. B is, Israel right now is extremely powerful, and it has the backing of the most powerful member states in the international system, most importantly, the United States. It doesn't really see much incentive to work within the ICJ system, because at the end of the day, it knows that any ICJ decision that needs enforcement from the United Nations will most likely be vetoed by the United States, which is a permanent member of the Security Council. So that's where we stand. These are the things that are an issue here, and this is where we are. I think the risk is, if there ever was a state, I think, and ever was a people that I think fundamentally have understood the traumas of genocide and the idea and the catastrophe of trying to kill a whole group of people for no reason but their own identity. In other words, the crime against the Enlightenment that is collective punishment. It is, of course, Israel in that sense. And the tragedy of this all could mean that at the end of the day, the country that was born after the worst catastrophe of the 20th century, which is the Nazi genocide of Jews, but also other groups such as Roma Gypsies during World War II, that led to the Genocide Convention. Israel's behavior in response to this could inadvertently gut the Genocide Convention of its promise, which would be a tremendous tragedy. Thank you very much. I'm very honored that you took the time to listen to me. Take care. Bye-bye.